seeks the following orders. 1. Habeas corpus directed to the respondents to produce the first applicant, dead or alive, before this court. 2. An order for the release of Mwenda Mbijiwe forthwith. Mwenda Mbijiwe is said to have disappeared on the 12th day of June 2021 while in the hands of state agents within Roysambu town while en route to Meru. This, in a nutshell, is what prompted this application. This application is opposed via a replying affidavit sworn by Frederick Okeo and filed on 15th December 2025, and a further affidavit filed by 2nd, 3rd, and 5th respondents on 10th February 2026 in response to applicant's supplementary affidavit. This matter proceeded by way of viva voce evidence. The second applicant testified on behalf of the applicants, whereas the investigating officer testified on behalf of the 2nd, 3rd, and 5th respondents. Article 51, Subarticle 2 of the Constitution provides as follows. A person who is detained or held in custody is entitled to petition for an order of habeas corpus. Section 389(1) of the Criminal Procedure Code provides for the right to habeas corpus in the following manner. And I quote, "The High Court may, whenever it thinks fit, direct A, that any person within the limits of Kenya be brought up before the court to be dealt with according to law. B, that any person illegally or improperly detained in public or private custody within those limits be set at liberty." From the above definitions, it comes out clearly that there are two limbs in regard to orders for habeas corpus, and these are: A, if a person is illegally detained or held by the respondents or their agents; B, if a person is illegally detained by identifiable persons other than the respondents. In the case of Grace Stuart Imbigira and others versus Uganda, 1966, cited in Mombasa High Court Petition number 7 of 2014, Masood Salim Hamed versus DPP and others, the East African Court of Appeal, which was sitting in Uganda, rendered itself thus: the writ of habeas corpus is a writ of right granted ex debito justitiae, but it is not a writ of course. the court laid down conditions. Thus, the second limb compelling respondents to lawfully retrieve the subject person from the illegal detention or custody by identifiable persons other than the respondents themselves is directly drawn from a purposive reading of Section 389, 1B of the Criminal Procedure Code. The applicants would need to satisfy the court that A, the subject person is still within the jurisdiction of the court, in this case, within the borders of the Republic of Kenya. B, the subject person is under the legal custody and detention of a specified or identifiable person or persons, not being the respondent or respondents whom the writ of habeas corpus is sought against. And C, the respondent or respondents can lawfully be directed by the court to retrieve the subject person from the illegal custody and detention of those specified or identifiable person or persons. And D, the ensuing writ of habeas corpus would be capable of enforcement by the respondents and would not be in vain. Our issues for this court's determination. A, whether the applicants have attained the threshold for the grant of a habeas corpus as prayed in the application. B, whether the applicants are entitled to the declarations and other orders they are seeking. Now, whether the required threshold for the grant of habeas corpus has been attained, it is straight law that he who alleges must prove. This is in line with the provisions of Section 107 of the Evidence Act. There is no dispute that the first applicant went missing on 12th day of June 2021, and that on 13th June 2021, the first applicant's stepmother made several calls to establish his whereabouts, but all in vain. The second applicant, who is the biological mother, was duly informed of this situation. A report was formally made at Central Police Station via OB number 75/16/6/2021. Another report was made at Langata Police Station via OB number 44/18/6/2021. To that extent, the disappearance of the first applicant stood documented. And proved. But it's not enough to prove disappearance for the court to grant habeas corpus. It is the duty of the applicants to prove that the first applicant was in the illegal custody of the respondents, or he was in illegal custody of identifiable persons other than the respondents. In the case of Masood Salim Ahmed, Supra, the court had this to observe. The general burden in a habeas corpus application must, pursuant to Section 107 of the Evidence Act, remain with the petitioners. As stated in the case of Estralalia de Martinez versus Director General and others, Supra, the petitioner must establish any competent and convincing evidence that the missing person on whose behalf the petition was filed is under the custody of the respondents. In this case, the petitioners were able to establish, that is in the case which I've quoted, and this was admitted by the respondents. The arrest of the subject by the police, and the question is on whether the police had the custody of the subject at the time of the habeas corpus proceedings. Where detention of an applicant is established, the burden of proving the legality of detention rests with the state. Further, end of quotes. In the case of the Law Society of Kenya and others, it was held whether under the first or second limb a writ of habeas corpus cannot be issued where the matter involves a mere disappearance of a person or the abduction or kidnapping by a person or persons unknown. For a writ of habeas corpus to be issued, the court must be satisfied that the respondent has or had custody of the subject person, or that it is just and proper that the respondent should be ordered to secure the liberty of the subject person because the fourfold criteria set out in the paragraph 21 above have all been met, end of quotes. In her evidence before the court, it was quite evident that the second applicant was not present when her son, who is the first applicant, disappeared. She did testify that on 12 June 21, she was not in Nairobi, but at her rural home in Meru. It was her evidence that Edward Mwangi Macharia, from whom her son had hired motor vehicle registration number KCN 641K, had informed her that the first applicant had been kidnapped. The court was of the view that this witness could throw some light on the disappearance of the first applicant. And this court did issue summons for the attendance of this witness. However, he did not present himself in court to testify on behalf of the applicants. The only evidence on the disappearance of the first applicant is that of his mother, that is the second applicant, who was nowhere near the scene of disappearance. To that extent, there is no evidence to indicate whether the first applicant was in illegal custody of the respondents or under the custody of a specified or identifiable person or persons. When the second applicant and her co-wife made a report to police, it was in the nature of a missing person, not an abduction. After a report of a missing person was made to police, thereafter information was received to the effect that the motor vehicle the first applicant was using at the time of disappearance was found abandoned near Tatu City and towed to Ruiru Police Station and released to Edward Munyeri Macharia, who was the owner. It is not clear whether any investigations were conducted at the place of recovery, that is at the scene, or on the vehicle itself. 4 years down the line, an application was made in court seeking orders to obtain the first applicant's IMEI history, call data, and geomapping details. In the year 2025, a flurry of activities were put in motion via letters to Banking Fraud Investigation Unit to check for post-disappearance financial transactions, another letter to Business Registration Service to establish ownership of in quotes, security, which was a company, another letter to NTSA seeking details of motor vehicles allegedly hired by the first applicant. These investigating tools were being activated 5 years after the disappearance of the first applicant. The question which comes to mind is, what value can these investigations yield after a duration of 5 years after the disappearance of the first applicant? In the case of Amnesty International Kenya and another versus Attorney General and 4 others, the court emphasized the constitutional mandate that investigations into disappearance of persons must be prompt, independent, and effective. The investigations into the disappearance of the first applicant are wanting in substance. However, having clearly indicated that the court's displeasure with the investigations, I hasten to point out that the main issue before this court in this application is that of habeas corpus application. This court has not been approached to supervise investigations in the matter or to give directions thereto. And I rest my observations on investigations at that. Conclusion. From the evidence adduced in court, a prima facie case has not been made to the effect that the first applicant was in the legal custody of the respondents. Secondly, whether the applicant was being illegally detained by a specified or identifiable person other than the respondent. This application, I find, has no merit and it is dismissed. There will be no orders as to costs, as I deem this to be a public matter. That's the ruling of the court.